Good afternoon, Your Honors. My name is John Drake of the Rutherford and Cannon County Bar. I represented Brady Holmgren at the trial court.
Do you want to reserve any time for rebuttal?
Yeah, I'd like to reserve 2 minutes.
All right, thank you.
I apologize, Your Honor.
It's okay.
And at the trial court, he was charged with a number of domestic assaults, and frankly, these were not proud moments for him. He beat up his girlfriend.
Mr. Drake, can I ask you a question before we get into the facts?
Yeah.
How do we have jurisdiction?
One of the problems with this case was that when the order was issued by Judge Tidwell revoking his furlough, that order was not filed with the trial court.
Let's say that we're reviewing Judge Turner's order. How do we have jurisdiction? That order is not one of the types of orders that's listed under Rule 3 of the Rules of Appellate Procedure, is it? Or is it?
I don't know, Your Honor.
I mean, we need to know that. It doesn't appear to be that it's one of the orders listed under Rule 3. If it's not listed under Rule 3 or not contained in the statute somewhere, how do we have jurisdiction?
Frankly, Your Honor, I don't know. And I know that's not a good answer, but I didn't research that before I came up here today.
Okay.
Go on to submit, though, that with Mr. Holmgren's case, he was placed, he was sentenced to 7 years, and then he was placed, after serving 90 days, he was placed on furlough with the Rutherford County Mental Health Court. Now, this case, we would suggest, affects a lot of these all of these community-based programs where you've got Veterans Court, you've got Mental Health Court, you've got Drug Court. All of these systems, at least in Rutherford County, is the way they're set up there. They're all put into furlough. And use of the term furlough, which we think is inappropriate, it may be in the rules, but the term furlough, typically you see that with wardens, sheriffs. They have the ability to furlough their inmates.
So do judges. It's right in the statute. They have the authority to do that. And was this following a jury trial and a contested sentencing?
It was not.
Hearing? This was a guilty plea.
Guilty plea, Your Honor. Yes, sir. This was his agreement.
Trial court didn't do anything here without the consent of your client, the defendant. He agreed on his guilty plea. I'm guessing, I'm asking you.
He did.
To these conditions.
He did.
Okay.
But the way these conditions were ultimately imposed upon him appeared terribly arbitrary. He called me from the jail and said that he had his furlough revoked because he wouldn't agree to address someone by their preferred pronouns. Now, there were other violations in the record leading up to that, but that was the linchpin moment that had him violated. He's in mental health court, and he can't wrap his mind around the concept of using a different pronoun for somebody should they request it.
Mr. Drake, are you familiar with State v. Bristol by any chance?
I am not, Your Honor.
From the Supreme Court. State v. Bristol came down in September, maybe August or September of 2022. And in that case, the Supreme Court reminded this court that typically appellate authority extends only to issues that are presented for review.
Yes, sir.
The reason I think that might be important in this case is that Rule 27 of the Rules of Appellate Procedure require the appellant to set forth an issue. I don't see an issue set forth in your appellate brief. I don't see there's not a heading that says statement of issue presented for review. There's not, in the argument section, I cannot determine what it is really that the issue is. Is it an issue with the original furlough, as it seems to be with Judge Hickson's questions? Is it the mental health court judge's revocation of the furlough? Is it Judge Turner's hearing? It seems like we're all kind of throwing all of those into a massive issue, but there's not an issue that's set forth in the brief.
Yes, sir.
Typically, when there's not an issue set forth in the brief, irrespective of whether we have jurisdiction or not, that issue is waived on appeal because we can't figure out what we're being asked to review. And at least in the case of, in the Bristol case, it's not the appellate courts that try to go around and figure out which wrongs to right. And there may be wrongs to right here, conceivably, but it's not the function of the appellate courts to do that. So if the brief doesn't have a statement of the issue, what are we to make of that here? Haven't you waived the entire presentation by not simply stating an issue?
I don't think so, because I think I
How
enumerated.
did you comply with 27A4?
I may not have complied, but I think I've enumerated repeatedly
What is the issue?
in my brief that Mr. Holmgren's due process rights were not adhered to. These are inherent due process rights.
Where? Are you talking about in the revocation of the furlough? Are you talking about in the granting of the furlough? Or are you talking about in Judge Turner's subsequent hearing?
In the revocation of the furlough by Judge Tidwell.
Okay, that's the issue?
Yes, sir.
All right, so your issue has nothing now to do with Judge Turner's order, is that correct? You see my problem?
Well, I understand that, but I mean, the
So
problem with
just-
Judge
just-
Turner's, the
just to
problem.
make- Just to make clear, I'm sorry, counsel, I don't mean to.
That's okay, I
don't mean to-
apologize, Your Honor.
No, I don't mean to interrupt. Just so that I'm clear, your issue on appeal is with the mental health court judge's revocation of the furlough. It is not with Judge Turner's subsequent order a year later. Is that correct?
I would think it's a twofold challenge because,
Now you see the problem that we
I
don't
do.
have an issue statement.
but in the allegation with Judge Turner is that he essentially approved the actions of Judge Tidwell.
So is it Judge Turner's order that you're appealing from, or is it Judge Tidwell's?
Well, it's Judge Turner's, I guess, in that respect.
All right, so you've told me a minute ago that it was Judge Tidwell's order, so.
Well, Judge
Counsel,
Ti- well,
counsel,
Judge-
help me, please. Help me understand what the issue is.
Judge Tidwell's order did not adhere to any due process rights. Judge Turner afforded some kind of muddled version.
Counsel, you have a sympathetic judge with me. I'm a former recovery court judge.
Yes, sir.
You have a sympathetic judge. I'm willing to listen to the due process arguments. In fact, I don't necessarily disagree that there may be some kind of liberty interest that should be protected. Help me understand the issue that you're raising.
The problem is, Judge, when all the power is handed over to the furlough judge, the recovery court judge, he really should turn around and refer back to the trial court that sent the individual. That didn't happen in this case.
Why? Why should he refer back? If I'm sending you to a specialty court judge on a furlough issue for whether it's drugs or mental health or whatever it is, and then there needs to be a determination of whether or not you completed that program, why does it need to go back to the other judge? Why shouldn't it not stay with the specialty court judge?
Because number one, there's an attempt to encourage ex parte communication between the court staff and the judge. And furthermore, the judge is supposed to, in those mental health recovery type courts, is supposed to foster a not an intimate relationship, but a casual, open relationship with these folks that are serving these furloughs, and they can't do that and then turn around and judge whether they violated the terms of the.
Well, how is that any different? I mean, how is that any different than a trial judge placing a defendant on probation or community corrections? Are you saying we need to give it to another judge to determine whether they violated probation or community corrections?
No, sir, I'm not. But because
So why is this different?
Because the recovery court judge is a recipient of ex parte communications. He's also, if he does that and judges it based upon what he knows about somebody as they process through the program, then
But that's part of what we're trying to determine.
notice.
That's what we're part of. I'm sorry, but I mean that's what we're. Judge Greenholz was more of an expert on this than I am, but as a recovery judge, a veterans court judge, or whatever the case may be, part of the reason we send you there is to create that relationship, is to give that understanding of what this person is going through, which puts you in the best light to determine whether or not they're meeting the criteria they're supposed to meet. I mean, that's my understanding of how these operate. So if that's the case, then that's the perfect person to determine Mr. Smith, Mr. Jones, despite everything we've talked about when you've been here, despite everything we've done, you can't get it done. So I'm going to unfortunately have to revoke your furlough.
Before you revoke my furlough, though, are you going to provide me notice? Are you going to afford me counsel? Or is there going to be a record? Is there going to be a courtroom? Is there going to be due process?
So I go back to Judge Greenholz's question, and what are we appealing? Because
there was no appeal that was taken from that order. That order wasn't even the subject of a filing for another year later. Even if the court had jurisdiction this court had jurisdiction under Rule 3, there was no notice of appeal that was filed within 30 days.
No,
there was
sir.
no notice of appeal that was filed. So let's assume that, just for sake of argument.
Exactly, because that order wasn't filed with court.
Just for sake of argument, let's assume there were due process violations. Lack of notice, lack of counsel, whatever. Let's assume that. There was no action at all taken to remedy that at the time. So there was not a notice of appeal filed to this court, even if we had jurisdiction. There was not a notice filed with Judge Turner to have him review the decision. There was not a motion to rehear with the recovery court judge. In essence, and once again I go back to the fact that there is no statement of the issue in this brief, if the issue here is with the recovery court judge's revocation of the furlough,
yes, sir,
the time for that remedy is long since gone.
I can only tell you how this case came about. I represented him on the plea. He pled. Then he goes to the recovery court. Then he calls me from the jail and says, I got thrown out of recovery court. He tells me why. He tells me it's because he didn't use the appropriate pronoun.
He's still in the Rutherford County Jail at this point.
Yes, sir.
Hadn't been shipped to.
Right.
So this is immediately after.
Yes, sir.
The rescission of his.
I can't find the order at that point. I'm looking for the order. That order wasn't put before in the court record until December, even though it was signed in March. I checked and I couldn't find it. Frankly, I had trouble believing him when he said it was over the issue that it was. And then ultimately we got into the meat of the matter, and that's exactly a big reason why, the last reason why he was put out of that particular recovery court.
So can you help me, please? Maybe, and I'll try this
Yes,
one
sir.
last time, please. I think I've said this already. I'm willing to consider the substantive issues. How do I get there procedurally? I don't think I've got a Rule 3 basis to hear your appeal.
Yes, sir.
I don't think, respectfully, that the brief itself complies with Rule 27. It doesn't set forth an issue. If the real complaint in the issue is with the recovery court judge's removal, that time has long since passed. I mean, it's ancient history by now. How do I get there to even consider the issues on the merits? Can you help me with that? Let's say you have me on the merits, just as a given. I don't know that you do, but let's assume that you do. How do I even get to the point where I'm discussing your issues substantively? Can you help?
Judge Turner said that he was going to go forward with the hearing despite the state's objections at the time.
All right, so is it Judge Turner's order we're reviewing?
Yes, sir.
Okay. How did he fail to comply with due process? Your client was represented by counsel. He had notice. He had the opportunity to be heard. He had the opportunity to cross-examine witnesses and present testimony in his own favor. Judge Turner entered a written order. How did Judge Turner not comply with due process?
By the time he adjudicated it, a lot of the facts, a lot of the basis for the facts, the witnesses were no longer employees of the recovery court.
But the state didn't deny anyone due process. That was because Mr. Holmgren didn't seek relief, right?
Didn't seek relief from what, sir?
From the removal from the recovery court until a year later.
He didn't. He called me. He wanted me to do that work. There wasn't an order in the court.
Okay, Judge Hickson, I'm sorry.
Taking a step back before Judge Turner's hearing, though, at that point, your client had been sent to corrections, correct, for
Correct.
some time.
Correct.
How did
Yes, sir.
Judge Turner even have jurisdiction to hold that hearing in the first place?
He assumed it.
Assumed it from, can courts assume
He
jurisdiction?
stated, I don't know. He stated that, to that effect. It's in the record. Because the state did bring that up. Now reserve any time I have left. Thank you.
Thank you, Mr. Brady.
General,
May it please the court, Jim Gaylord on behalf of the state.
what are we appealing?
The claim raised on appeal, despite the lack of an issue statement, is whether the rescission of the furlough violated due process. The difficulty
How do you
with
know? No, and I ask that in all seriousness. I mean, how do you know that? Because there is an issue with the original granting of the furlough. I don't know why we're talking about the original granting of the furlough. As Judge Hickson says, trial court judges have that authority. But it's in there. And then we're spending a lot of time talking about Judge Turner's order. And then you come up and say, really what we're talking about is just the rescission of the furlough. How do you know?
Well, Judge Turner was reviewing the rescission of the
Under
furlough.
no authority.
That is
He
true.
did not have Rule 35 authority.
No, he
I
did
think
not.
he was granting someone the right to have a hearing to do it, but there hasn't been a statement about why he had jurisdiction to do it.
No, he did not have jurisdiction. He was being generous because he was concerned about the circumstances.
As he would be, as he would be.
Yes.
We all know Judge Turner, and we know that he would be that way. So how do you know that it's just related to the rescission of the furlough?
Because what he's asking for is for it to go back to Judge Turner for notice, appointment of counsel, opportunity to call witnesses.
Should the case be dismissed on Rule 3?
Yes, it should. Because what the complaint is here is rescission of a furlough, Rule 3 does not speak to furloughs, so there is no appeal as of right. Nominally, the appeal comes to you as the denial of a Rule 35 motion. The motion itself didn't assert a jurisdictional basis, but what the judge said is, I think the program documentation here requires, after someone is terminated from mental health court, that it comes to me, it's remanded to me, and I impose the sentence. And since that didn't happen, I don't think it would be fair for me not to adjudicate the Rule 35 motion, even though 120 days had passed. The difficulty with this, of course, is that the 120-day time limit cannot be told. So the trial court didn't have jurisdiction.
So the actual order that we're being asked to review, irrespective of whatever else is in the brief, the actual order is a denial of a Rule 35 order.
He has appealed, the notice of appeal states that he is appealing from Judge Turner's order.
Okay.
But what he has asked for on appeal is a declaration by this court that the rescission violated due process, that he didn't get the remand to the sentencing judge to review whether the rescission was proper. The only way that claim can come to this court, since it is not in Rule 3, is via writ of certiorari. The defendant has not asked for that relief, and we don't believe, given the passage of time, among other things, that it would be proper. So to be clear, what the state is asking for in this case is that the appeal to be dismissed for want of appellate jurisdiction. If there were a vehicle by which this court could assume appellate jurisdiction, the only holding would be that the trial court, the sentencing court, Judge Turner, lacked jurisdiction to entertain the motion, because the only conceivable basis would be Rule 35, and too much time had passed. The rescission order was March 25th, 2022. The motion came nearly 11 months later in February 15th of 2023.
To be clear, Judge Turner would have had jurisdiction if he were still held in local custody prior to going to TDSC.
Yes, he would have had
Under
jurisdiction
212B,
to
yeah.
modify the sentence. But once Mr. Holmgren went to the Department of Corrections, June 16th, 2022, there was still a little bit of time left on the 120 days, but that time had long since passed by February 15th, 2023. So there simply was no basis for the trial court to assert jurisdiction. So in view of those jurisdictional problems, we don't believe that the court should get to the merits of the due process issue. And we don't see how the due process issue could be meaningfully addressed because the liberty interest that's granted is going to be governed by the program documentation, and that isn't in the record, although the parties...
Wouldn't there be a liberty interest akin to parolees in this case? I mean, essentially, the deal that's being struck in the recovery court is that so long as you comply with the recovery court procedures, the court will keep you on your liberty. And so the deal that fundamentally is struck is just like that in parole. That as long as you abide by the rules, you can stay out on your liberty. And so when the allegation comes that you have a violation of the rules, doesn't the recovery court person also have the limited liberty interest that a parolee would have?
Potentially, but again, we would need to look at the program documentation. There are certainly things in the record that we do have that suggest that there is a substantial liberty interest here. It's an extended furlough.
You'd have the right to notice. You would have the right to offer evidence. You'd have the right to confront evidence against you. I'm not necessarily sure you'd have the right to counsel, but maybe. And you'd have the right to an impartial judge, right?
If it were like parole, you would have all of those things. But there is one crucial difference that we certainly know exists here. And that is when you fulfill the terms of probationary sentence, you're done. You flattened your sentence. When you complete a furlough, you go back to the custody of the sentencing court. And the expectation on the part of the defendant, it was, well, if I do well in recovery court, then maybe the sentencing court will suspend the sentence or otherwise grant me some relief. But there is no promise to that effect. So that is, so the fact that conceivably someone who exits a recovery court is not done with the sentence is a substantial difference between a parolee and someone who completes a furlough. And that is probably going to inform the amount of process that we would do. So perhaps,
but I mean, in the context of a revocation of a furlough, you wouldn't agree that the two contexts are substantially the same?
No.
Revocation of a furlough for violation of the program orders versus revocation of parole?
No, I think the devil's going to be in the details. So what Judge Turner said here is that when these come to me, I do a show cause hearing, meaning that the burden of proof would be on the defendant to show why his sentence should not be imposed. That's not how we do parole. I think that's going to be okay given the reduced liberty interest that a furlough is going to have. The other thing is that Judge Turner did a review for arbitrariness. Again, that's not what we do in parole. For parole, it's preponderance of the evidence. Again, the state would suggest that that's probably just fine under due process, given the reduced liberty interest. But that question simply isn't presented today because there's no jurisdictional way for the court to get there. And it is at least possible that the program documentation could contain other significant restrictions on liberty that would also make it even less like parole. And we should take seriously the possibility that Judge Dyer has raised that maybe with a furlough, having the opportunity to explain yourself to the circuit court judge who is running the recovery court and then bring cert to this court if you don't like the result. That may be all the process that is due, but we just can't tell without the recovery documentation, court documentation, and there is no jurisdictional basis for us to even go there. So for that reason, we would ask this appeal to be dismissed. Thank you very much.
Thank you. All the last case.
State of Tennessee versus Sanquez, Kishon Jones, and Dion Jamar Glover.